Good afternoon and welcome to the Legal Hour with Bailey and Galyen. We're filming here today from the Legal Cafe at the corner of Main and First in downtown Fort Worth, just adjacent all the courthouses. Today I'm here with Michael Galyen of the law firm of Bailey and Galyen, and we're going to kind of chat about what kind of trials are going on these days and what's really happening in the areas of both family law and personal injury. Michael, what kind of cases do you primarily work on?
So as you said, I do mostly personal injury. I see car wrecks, I see truck wrecks, but I mostly specialize in work injuries. There are different subcategories of work injuries that I'm sure we can dive a little bit deeper into later, but the two main ones are third parties or non-subscribers. And so that's mostly what I'm dealing with these days.
Okay. Well, are you seeing a lot of cases actually going to trial today as opposed to settlements and other dispute resolutions?
You know, I would say it is not as common. The vast majority settle. By the time a case gets to me, somebody may have already tried to settle it at the firm prior to it getting to me, especially in car and truck wrecks. So in those sorts of cases, we'll deal directly with the insurance, try and get some sort of settlement, and if that doesn't happen, then we'll file a lawsuit. And even in the cases that lawsuits are filed, 95% are probably still settled at some point through the litigation process.
I would say I practice in family law, and we don't do nearly as many trials as we used to. And I would say that even a higher percentage of cases settle. I find that once you get into the case, you've conducted discovery, figured out where all the bodies are buried. Most of the time, at least in family law, the outcome becomes really predictable. And when you know what the judge sort of kind of has to do with these facts, I find it easier to give my clients good advice on settling. And a lot of times when you're settling a case, you've got a lot more control over how things play out and what the tax consequences are and things like that than you might have otherwise. Would you say that the outcome in most of the kinds of cases you're working on becomes predictable at some point?
I would say to a certain extent that's true. Now, I know personal injury law and family law are a bit different in that we mostly are dealing with jury trials, and correct me if I'm wrong, but in family law that's not often the case. A lot of the time it's tried to the judge.
That's true. That's true. In fact, I saw a statistic that said last year in Texas, there were only 72 jury trials in family court.
Wow.
Okay, so it really has become a lot more limited, and some of that has to do with the additional expense that's involved. And of course, you have to have a jury issue. So much of the family code leaves it up to the judge.
Right, and so in our case, once all the discovery is hashed out, like you had said, everybody knows where the bodies are. And we generally have an idea of where the issues are. And in personal injury, as I'm sure a lot of the time in family law, it comes down to the money.
Oh, yeah.
And now, at that point, we know where one side is, we know where the other side is, and especially if we go to a mediation, we can kind of hash out where there's a meeting point, and so a lot of the time that works out because we tell our clients, look, you could potentially take this amount of money, or you could go leave it up to 12 jurors who ultimately you don't know. They're just members of the voter registration block, and after voir dire, you're stuck with who you got, and they're going to ultimately decide how much money you get. And so some people want the crapshoot. Sometimes the defense attorneys leave us no choice, or they don't put enough money on the table to make settlement possible. But the vast majority of the time, you want to take the risk out of it and settle if you can.
I see it a little too often for my own comfort that sometimes I feel like one side is demanding a jury because they know what the proper outcome is and they're hoping to fool someone into making a mistake. Interesting, though, with juries. Let's chat about juries a second. I think you're right. A lot more juries get picked for personal injury types of cases than for family law these days. But a lot of people do not understand what voir dire is, or are we picking a jury or not?
Right, and that's a good point, because describing it as picking a jury isn't necessarily a good way of describing it, because you're given a pool of jurors, and these people are registered voters or people, when you go get your driver's license, you're dropped in to this pool to where they can call you up for jury duty. And now sometimes you're sent to the criminal court and sometimes you're sent to the civil court. And for a normal personal injury case, you're looking at around 40, 45 jurors on what we'd call the veneer panel. And so they all come in, and the plaintiff's attorney and the defense attorney get an opportunity to ask a whole bunch of questions. And then based off of those questions, we're trying to get rid of the jurors who cannot serve on the jury. So it's not as much picking as getting rid of those who either can't serve on the jury for a reason, like they can't understand English, or maybe they've committed a felony, in which case they should have been tossed out of the jury pool anyway. But it's more of a process of elimination than it is picking.
Absolutely. And a lot of times people get their feelings hurt about getting knocked off a jury. But the fact of the matter is, you have a bunch of rows of people who are in a certain order, and the attorneys have some strikes that they can use to get rid of people who should not be on the jury. And the judge can excuse some members for cause. But what we're trying to do is eliminate the people that have a really bad bias about this case. And it's not a character flaw, but there may be something in a juror's background that is so emotional and so important to them that it's really difficult for them to sit through this without being triggered or without perhaps putting the burden on some party that shouldn't have the burden on them.
Right, and we run into that obviously in almost every voir dire we handle. And you'd mentioned there's different ways to strike a juror. One is for cause, meaning there is a legal reason, and the judge agrees that they have some sort of bias or prejudice as to why they can't serve on the jury. And then once we go through that process, then there are peremptory strikes where each side, in most cases, they get 6, where we go through the jurors who are still left on the panel and say, okay, while legally they may have not said something that disqualified them from the jury, they said something that bothered us a little bit, and we don't feel comfortable having them on our jury. So we get to strike another 6 of those. And then, like you'd said, it's juror 1 through, let's say, 45. And we just count up. And so if 1 was struck for cause, and then we struck 3, 6, and 9, and then you just count up. Whichever ones are remaining, then they just grab the first 12.
There you go.
And that's how we end up with them. But interestingly enough, the reasons for cause that we can find are, for example, in a personal injury case, somebody may say that a family member of theirs or a child were involved in a serious accident, and they get emotional, and that's completely understandable that they don't want to sit in judgment of that case. And so,
sure.
That's what will happen sometimes, and those people aren't comfortable serving on the jury, so the judge will let them go.
Sometimes, when you're doing a lawsuit, various areas of the law kind of merge in together. And I can't think of a better example for that to happen than when the victim in a personal injury is a minor.
Yeah, absolutely. And I think this is where we have a bit of overlap between personal injury and family law issues, in that when a minor suffers an injury as a result of a personal injury, whether it be a car wreck, a truck wreck, or any other premise liability, the child isn't given the money then and there, because the problem is you can't give a 10-year-old child, say, $20,000 if they're injured, and that's the kind of recovery they get. So we have to do what's called a friendly suit, or a minor prove up is the more casual term I guess we use. And the court has to determine the best way to set aside that money. And I know, in family law we talk about, or you talk about, the interest of the child being so important, and that's what the judges are looking at in these situations as well.
Back in the day, I had a couple of personal injury cases involving children, and sometimes you see some really unusual circumstances. So, for example, if you have a 6-year-old child and they are injured and they are going to require surgery later in life, we end up where we have to set up annuities or other fail-safe mechanisms to make sure that the money is available for them at that time, or maybe they have some metal pins that are going to have to be removed later. How do you decide how you're going to handle that?
So luckily, we don't have to decide. The court will appoint what's called a guardian ad litem. And the guardian ad litem is there to represent the interest of the child. And so together, between ourselves, the parents of the child, and the guardian ad litem, we will put together recommendations and go to the judge. And ultimately, the judge has to sign off on exactly where the money is going, and they want to know why it's going there. So that is the important part of the process, where the judge ultimately determines whether they're comfortable with the decisions being made on behalf of the child.
Well, and part of the concern is also to make sure that the money that's set aside for the child doesn't get spent on a new Ferrari for one of the parents, because it's there, we might as well spend it, right? Kind of thing.
Yeah.
Go ahead.
On that point, I would say the vast majority of the time, these parents aren't planning to go out and spend it on a Ferrari. They think the child needs new clothes, they need school supplies. We pay rent, we're behind on rent, car payments.
Mm-hmm.
This is all to help the child. Why can't we have access to the money now? Unfortunately, our law just does not allow for that. The child is the one that suffered the injury, and ultimately it's their money, and so it has to sit, like you said, in an annuity or sometimes the registry of the court until they become the age of majority and can actually get that money.
Do you find that there's much of a difference between rural and urban areas or different parts of the state in terms of jury awards?
That is a pretty big issue, and it's back to the idea of voir dire, right? The jury panel that you get is a jury of your peers, and the peers that you're getting is based off of the county where the suit's filed. So if an accident happens in Dallas County, the case is filed in Dallas County District Court, you're going to get registered voters from Dallas. And so the potential jurors you may get in Dallas is going to be different than if you're out in West Texas or East Texas or even South Texas. So it really does depend on the case. A good plaintiff's attorney should be able to prove the damages regardless of what jury they're in front of. But if you run it by the numbers, yes, the larger counties, your Harris County, Dallas County, Travis County, you will likely see larger awards than those awarded in some of the smaller counties.
A little more plaintiff-friendly?
Yeah, and again, it depends on the case. Sometimes, especially in the ones that I deal with, work injuries, I think everybody can understand, when a worker gets injured, and especially when the company did something just so negligent that they're going to be fair and provide fair compensation. And ultimately, it's the jury's decision, right? It's a jury of your peers. They determine what's full and fair compensation, and sometimes in certain counties it's less, and sometimes it's more. So we do see a difference, but it all just comes down to the case.
Well, and a lot of times I think while you may be talking about some counties statistically may be more plaintiff-friendly or more defense-friendly in terms of the amount of the judgment, you still have to prove a number of elements to be entitled for a jury to even give you an award. And it's something we don't talk about much in the media, but if you're injured, you have certain things you have to prove to the court that would allow them to find that someone else is responsible for some of those damages. What kinds of things do you need to prove?
Yeah, absolutely. And so that's the biggest thing. You bring up the media, and it's easy these days to harp on the media, right? Nobody likes the media. But for example, McDonald's hot coffee and all of these cases that really brought about this idea that plaintiffs are out there getting these huge awards and companies didn't do anything wrong. Oh, the woman she just dropped her coffee on herself. But no, you're right. When we go to court,
allegedly,
when we go to court, we have to prove the elements of negligence if that's the case in front of us. We have to show that the defendant owed a duty to the plaintiff. We have to show that they breached the duty. We have to show that their breach of the duty was the proximate cause of the injury sustained, and that ultimately the plaintiff is entitled to damages as a result of that breach. So, we have to systematically lay out exactly what the defendant did wrong and show that their wrongdoing ultimately caused the injuries. So it's a tough process, and we have appellate courts in the state all the way up to the Texas Supreme Court that if you don't meet those elements, the defendant will take you right up on appeal, and even if the jury decided in your favor, some other judges may say you didn't meet that burden.
I think a lot of people think, well, we feel sorry for them or that sort of thing, because you're right. Everybody likes to be mad at the media, and maybe it's time constraints or whatever, but you never hear the whole explanation, and so what you get is something that is so simplified that it's frequently false.
Right.
Okay, and so the fact of the matter is that the burden of proof for a petitioner is very high.
Sure.
And there are limits on what a jury can do after tort reform. I'm not sure everyone understands that.
Right. There are limits on, in some cases, what the jury can award, especially medical malpractice. I don't specialize in it, so I'm not too privy to all the details, but there are caps on non-economic damages, for example, in that area. And again, like you said, the burden of proof. We have to prove by a preponderance of the evidence all of the elements of our case. And, these are all the things we have to not only explain to the jury through the voir dire process and the trial to make sure that they understand what our burden is, and then also meet that burden once we've explained it. So, like you said, it's not a plaintiff getting up there and telling a sob story, the jury feeling bad for them and giving them money. There are a lot of moving parts of legal elements that we have to meet, and the jury has to decide it. The judge oversees the entire thing, and then if for some reason a wrong determination is made, then they'll take us up on appeal as quickly as they can.
Trying a personal injury case, we've talked about it's a burdensome ordeal, but it's also very expensive for the attorneys. I don't know if everyone understands. You don't charge your client a fee unless you win for him, correct?
That's correct. We do not, and you're right, it is expensive. If we talk about a lot of cases requiring experts, definitely not cheap. All the depositions, we have to have court reporters at each of those depositions, sometimes videographers, and this is before we even get to trial. And then once we do, we again have to pay for these people's time to come out, especially experts. We take all the time and all these days to prepare for trial, prepare our clients for trial, and then go and spend the time in the courthouse during trial. And we do not charge anything unless we win. That's how we recover a fee. So it's what's called a contingency fee, that it's contingent on if we win, then we get a percentage, but no upfront cost to our clients.
Now, there's a different element. Every case is different, and I think most people understand that, but injuries in the workplace can be particularly unusual in Texas.
Yes. So what's interesting is that I'm sure most of our listeners at some point or another have heard of workers' comp or workers' compensation insurance. Texas is the only state in the country that does not require an employer carry workers' compensation insurance. And a lot of the larger employers in the state don't. And the reason for that is they'll self-insure. So they'll go out and buy insurance through an insurance company rather than using the state workers' comp system. And, your Walmarts and Targets and Home Depots and Amazons.
Deep pockets.
Right. And so they would prefer to self-insure because ultimately they believe it saves them more money in the long run rather than having to pay through the state workers' comp system. Now, the benefit of that is that if your employer does have workers' comp, that is the exclusive remedy if you're injured. Now, the benefit is it's no-fault insurance. So
if I'm in Oklahoma and I get my my hand smashed in a pneumatic press, I've got somewhere to go.
Right. If your employer has workers' comp, and I don't practice in Oklahoma, but generally
I just picked a non-Texas state.
Right. The idea is if your employer has workers' comp insurance, you are in the course and scope of employment, and you get hurt, then that insurance will cover that on-the-job injury. Now, in Texas, a lot of employers still carry workers' comp, but for those who don't, if you get hurt like that, you aren't barred from bringing suit against your employer if they did something wrong. So that is a potential benefit because a lot of the time the workers' compensation insurance system does not provide a full set of care. You may get your hand smashed, like you say, and they'll send you to a Care Now or a Concentra or what some people refer to as like a doc in the box, and you go here and get all your care, and you don't get any follow-up. They won't send you to a hand specialist, maybe. They won't send you for certain types of specialized PT. And this is obviously, not, it's case specific, but a lot of complaints I hear is that these workers' comp policies do not provide full and fair compensation for some of these injuries. So if your employer is what's called a non-subscriber, you can bring a lawsuit against them for injuries that you sustain on the job.
One thing we know happens is you're involved in either an accident or a workplace injury, you're hurt, and perhaps you can't work. And suddenly, attorneys from insurance companies are coming out of the woodwork saying, sign right here, would you?
Yeah.
What kind of advice would you give someone who finds himself in that situation, particularly if they all of a sudden find they have attorneys in their hospital bedroom?
Yeah, absolutely. And that does happen, and it is very concerning when it does happen. I think if you have suffered an injury, whether it be car accident, truck accident, workplace injury, a lot of the time, especially in workplace injuries, people trust their employer. They think that they have my best interest in mind, especially after I'm injured. Hey, just sign here. You need to sign this so we can get you the care that you need. I would hesitate to sign anything after an accident or an injury without having your own attorney review it. Give us a call. Give any personal injury attorney who specializes in work injuries or handles them to review those documents before you sign it. I mean, I'll have clients just text me a picture of a document and say, hey, my employer just gave this to me and said that I need to sign this before they can do X. Is that true? And I'll as soon as I get a chance, I'll look at it right away and let them know. Mm-hmm. Sometimes it's harmless, but you don't want to take that risk.
It seems to me, too, that now we all want, to solve our problems as quickly as we can and address them. But particularly with injuries, it seems to me that sometimes you may not know how long you're going to need treatment, or you may not know whether or not the treatment you've been receiving is successful. Will something else be required? You mentioned a hand specialist a minute ago. Obviously, if you can't work your hand anymore, they may have bandaged it up and it may not be bleeding, but you might not be able to work or use it for the task you're trained for. It would seem to me that sometimes moving too quickly may not be advantageous to the client.
I think that's right. When you settle a personal injury case, whether it be car wreck, work injury, you are oftentimes signing a release that releases them from all claims moving forward. So let's say you get into a wreck Monday and they offer you a whole bunch of money on Wednesday and you think, wow, this is great. I went to the hospital, they ran all the scans, checked me out. They said I was okay. I could leave the hospital. My hospital bill was $3,000, but the insurance company said they'd give me $5,000. I really need that $2,000. I'll pocket that. Mm-hmm. I would hesitate very much so to do that, especially if all you went to is the hospital, because they're just running CAT scans most of the time, x-rays, stuff to make sure that you aren't severely injured and need to stay in the hospital at that moment. But they oftentimes will not run MRIs. If you have a bulging disc in your back that may require surgery or injections later, the hospital is not looking out for that. So I think it's best to get fully checked out after something like that and then at that point determine whether or not it's a settlement you're comfortable with taking. Because once you sign that paper, that's it. You can't go back to them and say, oh, well, I went to the doctor now that my back's hurting, and they said it's related to the accident. Too bad. You signed it away.
When a client comes in to see you and they're injured, are there times when you yourself go ahead and say, look, I'm sending you to a doctor because we need more information before we can tell you whether or not this is a good settlement?
Yeah, absolutely. I mean, a lot of the time we will have clients who may not have health insurance or, are uncomfortable with the care that they're receiving. And we can suggest healthcare providers that will operate or see them without any upfront cost to them.
Okay.
And there are a lot of doctors out there who will do that. Ultimately, the choice is up to our client where they'd like to go, but we can give them suggestions on doctors who will see them if they don't have health insurance, if they really need a second opinion. And some of them will take advantage of that. And I think, like I said, if you just go to the hospital, they're not checking everything out. You really do need to make sure that you are fully looked over by a doctor before you sign a settlement agreement, because you may have a 4-millimeter bulging disc in your back, which doesn't sound like a lot, but if you have one, it is. And that may not flare up until a week, a month down the road.
Well, it's been my experience, because I'm an old guy, that sometimes you want to see a doctor and they may say, I can work you in September.
Yeah.
And that's not really going to help you, and you have to go find someone who can help you find a doctor who can see you a little bit sooner, because you can't wait for forever.
Yeah, that's true. And so, if there's a specific doctor that somebody wants to see and they say it's going to be 3 months, 4 months, but you really need to be seen quickly, again, we can suggest doctors that will be near you, that will charge you no upfront cost, and ultimately they'll be paid back out of a portion of the settlement that we ultimately receive, because they do need to be paid back. But again, no upfront cost to you. And those sorts of situations clients take advantage of pretty often, I'd say. Hey everyone, I hope you're enjoying the podcast. I just wanted to take a quick moment to provide a caveat to some of the discussion that Keith and myself were having just then, and that's specifically related to the medical providers that I had talked about. Now, while there may not be an upfront cost to you as it relates to these medical providers, that does not mean that they are still not billing you. So in the event that there is not a verdict or settlement in your favor, you may still owe these bills to the medical provider. I didn't make that clear, and I just wanted to do so at this point. So I hope you enjoy the rest of the podcast. And if you have any other questions, always feel free to give us a call.
Good. Okay. Well, let me ask you a question about a term that I know we hear it on TV, we see it in the legal shows, contributory negligence. And I think that's a concept that many of us are not familiar with.
Right. So when you take a case to trial, there ultimately will oftentimes be blanks on the jury charge, right? So let's say it's a car wreck. You're saying, I didn't run the red light and they did, for example. And they're saying the opposite. No, they ran the red light and I didn't. Ultimately, the jury is going to determine who was negligent. And, we went through those elements earlier, but we'll skip past that. And then there's a portion on the jury charge where they'll have to assign fault. And they'll say out of 100%, you have to give them a number. Is it 50-50, 40-60? Ultimately, the contributory negligence is how much was the plaintiff or you responsible for that accident? Mm-hmm. And the same concept works out in all kinds of injuries, whether it be a slip and fall or a work injury. And we can come back to work injury because the rules are different in Texas for that. But on the main ones, car wrecks, truck wrecks, slip and falls, those sorts of things, contributory negligence is a big factor, because ultimately if the jury says you're entitled to $100,000, but you were 20% at fault, then ultimately your recovery is going to be reduced by what you were determined to be at fault for. So you'd end up with $80,000.
Okay, but even if you were partially at fault, as long as you weren't the one responsible for all of it?
Correct. Once you get over that 50% threshold, then you can ultimately recover. However, whatever award the jury gives you will be reduced by what percent of fault they give you.
Okay. All right. Now, a lot of the cases, you've told me, we either go to trial or we reach a settlement, but we haven't talked about arbitrations, and arbitrations are kind of a big deal, and it's kind of its own little animal.
It really is. We see them a lot in work injuries. A lot of times, these employers who are not giving you workers' comp insurance or giving you something that will be titled a work injury benefit plan or a work injury agreement of some sort. And essentially, you sign it with all your onboarding documents. And they say, if you're hurt, we'll get you some medical care. However, you have to agree that you're subject to an arbitration rather than sue us. Because remember I said, if they don't have workers' comp, you're allowed to sue them. But they don't want all their dirty laundry aired in court, so they'll instead ask for a private arbitration. And employees at all of these large companies, your Amazons, your Walmarts, your Targets, oftentimes they'll have you sign an arbitration agreement as part of your onboarding documents to make sure that if you do get hurt and it's their fault, that you stay out of court.
Okay. So that's in that big pile of papers that they give you to sign when you get your job?
It is.
You want to start Thursday? Yeah.
Yeah, and it's unfortunate that's the rules, because you talk to somebody, I've worked at X company for 10 years. I don't remember what I signed when I came on. You're saying now I'm stuck with an arbitration? Unfortunately, yes.
Okay.
There are limited legal exceptions that the Supreme Court has set out, which apply in some cases regarding transportation workers, but we don't need to get into the nitty-gritty of that now.
Okay.
But ultimately in arbitration, it's private, it's quick, but you are limited to a single individual, an arbitrator, who is your judge, jury, and executioner.
Oh, wow. Okay.
It's a bit different than getting 12 jurors, of your peers that make the determination.
So, if someone's driving home this afternoon and they're involved in an automobile accident, maybe with a 18-wheeler, serious accident, what would you want to tell them to do first, and what would you want to tell them not to do?
Absolutely. If you're involved in an accident like that, first and foremost, call 911. You want the authorities out there for all sorts of reasons, whether it's taking witness statements, documenting evidence, investigating what happened. And if EMS or fire or other services need to come out, they can assist with that. So first and foremost, that's what you want to do. Then if you have the opportunity to talk to the other driver and exchange insurance information, obviously that's helpful as well. You want to take pictures. If somebody witnessed the accident, make sure you get their contact information. And you want to call an attorney as quickly as possible. If you need to go to the hospital and obviously those sorts of things, do that first. Call an attorney afterward. However, there are time deadlines for filing claims. Evidence will disappear. Maybe you got involved in an accident and it was right by McDonald's and their camera caught it. Those footage will go away relatively quickly. So the quicker you get it to an attorney, the quicker we can make sure that all of that evidence is kept, so that we can ultimately help you get a successful claim.
Do you find that, especially with guys, that I'm fine, shake it off, I'm tough? I've known a lot of people who had these accidents, and they walked away from it, but they weren't walking too spry the next week.
Yeah, and look, us guys oftentimes do that. And even, there's women like that, obviously, as well, that you get in an accident and you think, I'm too busy for this. Uh-huh. I'm not going to the hospital. I got to go pick up my kid, and then I have to drop them off at piano lessons, and then I have work in the morning. I'm not dealing with this. Mm-hmm. And then the insurance company will offer them to pay for their car, to get them a new one, and then say, I'll give you $2,000 and, wipe their hands clean of it. And the whole time, you're sitting there a week, 2 weeks, 3 weeks later, and man, your back is killing you, or you're having trouble putting pressure on that leg, and you accepted that money that they offered you, that 2 or 3 grand, and that's it. So I would hesitate to try and act like the strong man or woman right then, and just make sure that you talk to somebody who deals with this for a living, like a personal injury attorney, and ask for their advice, because if you don't get checked out, then you miss your chance, and you don't want to go on living the rest of your life thinking, man, this back has been killing me for the last 20 years. If only I just went and got checked out and I dealt with it at the source, then maybe I could be better today. So.
All right. And Michael, if someone's facing an injury, things like that, how can they get in touch with you?
Sure. So I work at the law offices of Bailey and Galyen. You can go to thetexasattorney.com. You can call 1-800-LAW-OFFICE. You tell them that, hey, I was involved in an injury, I need to speak to Michael Galyen. They'll get a hold of me. If I'm not in court or in a deposition, I'll take a call. So please reach out. We're here to help. Even if you don't end up hiring me, I would love to give you some advice and make sure that you follow the right steps following an accident.
And it doesn't cost anything to give you a call and chat with you?
No, absolutely. You give me a call and chat with me for as long as you'd like. I'll give you all the advice you could need, or that I can give you. And no, it's not going to cost you anything.
Terrific. If you have any questions, give Michael a call. These injuries can follow you for a lifetime. And so you really want to kind of take a breath and examine your situation, have the doctors check you out, make sure that you haven't missed something or that it hasn't exacerbated something else to make it worse. But give Michael a call at Bailey and Galyen. We've enjoyed talking to you today. This is the Legal Hour from Bailey and Galyen, and we're filming today from the Legal Cafe on the corner of Main and First Street, right next to all the courthouses. Stop by, have a cup of coffee, and talk to a lawyer.
Thanks for having me, Keith.
You bet.